Hello, welcome back to another episode of our Dig Deep Company Law series. Today, we are going to explore two crucial doctrines under the Companies Act 2013, the doctrine of constructive notice and the doctrine of indoor management. These doctrines play a vital role in how companies interact with the outside world. Let's dig deep and understand what they are all about. First, let's talk about the doctrine of constructive notice. This doctrine is a legal fiction created by the courts. It signifies that a person or entity should be aware of certain legal actions, even if they have no actual knowledge of them. It helps streamline business regulations and provides security to companies dealing with outsiders. Under the Companies Act 2013, a company is defined as a body corporate registered under the Act. It's governed by its own constitution, primarily the Memorandum of Association, MOA, and Articles of Association, AOA. These documents outline the company's powers, objectives, and business nature, and are registered with the Registrar of Companies. The doctrine of constructive notice means that any person dealing with a company is presumed to be aware of its MOA and AOA because these documents are public records. This presumption aims to reduce the company's liability, assuming everyone should know the company's rules and regulations before engaging in any transaction. Section 398 of the Companies Act requires the registrar to inspect all incorporation documents, which are public documents. Section 399 allows anyone to inspect, extract, or make records of these documents upon paying a specified fee. So, the MOA and AOA of a company are always available for public scrutiny. Let's look at some case laws to better understand this doctrine. Kotler Venkaswamy versus Ram Kurthi. The court held that a deed not signed by all required persons, as per the company's articles, was invalid. Oakbank Oil Co. v. Crum. Anyone dealing with a company is presumed to have read and understood its MOA and AOA. Mahoney v. East Holyford Mining Co. The court stated that anyone dealing with a joint stock company is affected by notice of all that is contained in its MOA and AOA. Griffith versus Paget. It's presumed that individuals dealing with a company have read and understood all documents related to the deal. Ernest v. Nicholas. It was held that anyone dealing with a company is deemed familiar with its public documents. Rama Corporation v. Proved Tin and General Investment Company. The court applied the doctrine, holding that the company was not bound by an agreement made without proper authority. This is where the doctrine of indoor management comes in as an exception. The doctrine of indoor management protects outsiders dealing with a company from being affected by its internal irregularities. This doctrine was first enunciated in the case of Royal British Bank v. Turquoise. The court held that outsiders are entitled to assume that all internal company requirements have been met. Here are some key case laws illustrating this doctrine. Varki Surya vs. Kerala Banking Company Limited. It was held that a person dealing with a company does not need to inquire about its internal proceedings. Lakshmi Ratan Cotton Mills Company Limited v. J.K. Jute Mills Company Limited. The court held that the company cannot be expected to know an internal rule of the debtor company. Freeman v. Backhurst Park Properties Limited. The court held that the company was liable for the services provided by the plaintiff despite internal irregularities. Howard v. Patent Ivory Manufacturing Companies. Directors could not defend the issue of debentures due to their knowledge of the need for a general meeting's assent. Anand Bahari Lal v. Dinshaw. The court ruled that an outsider should have been more cautious when dealing with the company's accountant. Reuben v. Great Fingal Consolidated. The company was not liable for a fraudulent transaction involving forged signatures. Ford Motor Credit Co. Limited v. Harmac. Lord Denning. Are observed that it's presumed that internal company requirements have been met when dealing with authorized persons. In conclusion, while the doctrine of constructive notice ensures that outsiders are aware of a company's public documents, the doctrine of indoor management protects them from being affected by internal irregularities. These doctrines together create a balanced framework for corporate interactions. Thanks for watching, Legal Genies. If you found this video helpful, don't forget to like, share, and subscribe to our channel. Hit the bell icon to stay updated with our latest videos. See you in the next episode where we continue to dig deep into company law. Bye for now.